And I think since we have slightly overshot the time, I will ask the discussants to come in now. Our first discussant is Professor Sangmin Shim. He is an assistant professor and head of the Center for International Law at the Korean National Diplomatic Academy. Professor Shim also writes widely on other international law subjects and advises the Korean Ministry of Foreign Affairs on newly emerging international legal topics ranging from biodiversity, access to genetic resources, and benefit sharing. Professor Shim, you have the floor.
Thank you, Judge. Thank you, Judge Chadha, for your wonderful introduction of myself. And I'm really grateful for the organizers of this conference for giving me the opportunity to make a comment on three eminent scholars of the law of the sea. And each of the presentation and the paper that I read were very informative, and I learned a lot from studying this material. And I really appreciate each of the presenters for their wonderful contribution to the development on the issue of the law of the sea. For the sake of the time management, I'd like my comments to be very brief, and I have only one comment or question to each of the presenters. To Professor Young's presentation, I find it very interesting that we probably will come across certain challenges and possible inconsistencies dealing with the protection of marine environment from different institutional perspectives. And I find it very interesting that she pointed out that the worldwide agreement on the prohibition of the fishery subsidies is mostly welcome and rewarding. But I'd like to raise a certain other angle to that question, which is there might be certain subsidies given out to those fisheries industries that might have certain pro-environmental purposes. For example, when we think of implementing the most recent regulation by the International Maritime Organization, which is to use very low sulfur content fuel in certain categories of ships, those fisheries ship owners might not have the financial resources available to readily resort to those low sulfur content fuel. Probably that's where the governments need to subsidize those ship owners to just compensate to help them pay for the more expensive fuel to comply with the IMO regulations. And those kind of subsidies might have some certain advantages in terms of making the whole the fishing operating vessels eco-friendly and environmental friendly. I don't know if Professor Young would be also against the idea of giving out subsidies to those ship owners that might need to do a fuel switch. And another example that I could think of that may have certain environmental protection purposes is to what can be said as scrap and build rules by by big ship operator by fishing vessel operators. Some governments, including China and Korea, they have a program to subsidize those fishing vessel owners by a new and brand new and more efficient fishing vessels with the governmental subsidies. That might have also pro-environmental consequences because there are ships now equipped with more efficient fishing equipment and the better and more efficient engines. They may be more environmental friendly, and they also have certain possibilities to just to do their fisheries with pro-environmental perspectives. So these are the examples that I could think of as some subsidies that may have certain pro-environmental consequences or purposes. And I'm not sure if those are worldwide agreement on prohibition of the fisheries subsidies might include those what I can call as good intention, the subsidies with good intention. And as to the Professor Proelss' presentation, I found it very interesting that he covered certain possibilities of inconsistencies depending upon different institutional or regulatory frameworks. And I found it interesting that the discharges, the wet scrubbing wash water is also subject to a certain kind of regulations. I'm not an expert on this topic, but while preparing for the comments to Professor Proelss' paper, I found that there is more than one category of scrubbing technologies. And Professor Proelss introduced to us the web scrubbing technology, but there is also another category called dry scrubbing device technology, which does not use liquid to take acid contents from the flue gas, exhaust gas. So I'm not sure if just mandating the use of wet dry scrubbing technology all throughout the member states of the European Union would be more environmental friendly and would be also just as cost effective compared to the choice that might just mandate all the ship owners and the ship operators to use low sulfur content fuel throughout the operation of the ships. That is a question for Professor Proelss. And as for Professor Harrison's wonderful introduction of wonderful analysis of the management of environmental resources in the Arctic region and the South Ocean, I was wondering if his last comment as he concluded his presentation, which is the relationship between the management of Arctic environmental protection and then the discussions within the UN context of the conservation and the sustainable use of marine biodiversity of areas beyond national jurisdictions. And he mentioned that he could see certain possibilities of improved regulatory setting in the Arctic Ocean when the discussion is complete at the UN level on the formation of international legally binding instrument on this topic. But given the discussion that I have witnessed so far, I get the sense that there is still a discussion going on what would be the proper management, proper institutional framework dealing with the resources found in areas beyond national jurisdictions. There is a group of countries in favor of designating the conference of the parties to have a central role in issuing out regulations related to this, but some other countries are in favor of leaving the RFMOs more discretion on just bringing out regulations on these topics. So I don't know if if it can get more productive results just by waiting out the completion of the international dialogue on this PBNJ issues at the UN context. But anyway, I really learned a lot from three of the wonderful presenters, and I deeply appreciate their great contribution to the increase in knowledge of the law of the sea. Thank you very much.
Thank you very much, Professor SHIM. I think I'll give the floor to the second discussant before I ask the panelists to respond to the questions. The next discussant is Dr. Tran Truong Thuy. He's a Minister Counselor, Deputy Chief of Mission, Embassy of the Socialist Republic of Vietnam in the Republic of Korea. Earlier, Dr. Thuy was the Executive Director of the Foundation for East Sea Studies and was a Deputy Director and Senior Research Fellow at the Institute of Maritime Studies. Before joining the Diplomatic Academy of Vietnam, he worked as a policy analyst at the European Department, Ministry of Foreign Affairs of Vietnam. Dr. Thuy, you have the floor, please.
Thank you very much, Judge Chadha. Before comment on three presentations, I'd like to thank organizers, the Korean Ministry of Foreign Affairs, Tribunal, International Tribunal of International Law, I Love the Sea, and Korean Society of International Law for inviting me to this very important conference. And I'm a student of international law, and especially in this panel, I learned a lot from three presenters. And I would like to share some of my personal observation and also some questions specifically to speakers. Listening to three presentations, we can see a quite comprehensive pictures regarding many aspects of the sea, including marine scientific research, marine science protection, maritime environmental protection, conservation of living resources, and discharge from the sea, and also the relationship between law of the sea system and trading system. I have some common questions and also specific questions to each speakers. The first question is about the regional or specific system arrangement here. When we talk in the EU system of regulation regarding to the discharge of the ship, as Professor Proelss mentioned, that IMO is more or less provide general regulations, and the EU to some extent regionalize or make more specific certain regulation regarding the environmental protection from discharge from ship. Or in the presentation by Professor Harrison regarding the Antarctic treaty system, we see to some extent some countries, right, not all countries, a dozen of countries adopted some agreements regulating Antarctica or southern oceans. So to some extent, that is also relating among themselves, so signatories of this system of agreements. So my question is, how about this regional arrangement or specific arrangement relating to the third party, non-signatories? For example, in the EU regulation regarding to the discharge of ship, to some extent it's more than the IMO regulations, and how it's applicable to the ships from the third party. Or in the case of Antarctic treaty system, how the regulation relating to marine environmental protection or conservation of living resources apply to entity from the third parties, given the third party is not signatories of the regime. And relating to that aspect, specifically to Professor Harrison, is the question about the relationship between Antarctic treaty system with UNCLOS, UN Convention on the Law of the Sea. In your presentation, you mentioned a lot about relationship between different agreement within the system, this treaty system, relationship with regional instruments or regional cooperation, fishing cooperation. But my question is more is about relationship with UNCLOS. as we understand that beyond the national jurisdiction or beyond EZ on continental shelf, we have the area or the high sea that belong to all mankind, right? So to my understanding, the Antarctica, to some extent, it can be characterized as the high sea or the area beyond the national jurisdiction. So it's also belong to the whole international communities. But here we have a system of treaties, only a number of countries, 30 or something, 40, some countries sitting among each other and adopt the regulation, regulates the whole areas. So the question again, the relationship between the Antarctic treaty system with UNCLOS. The fourth, my another question, this also to Professor Harrison and also to Professor Young, about relationship between IUU fishing and marine environmental protection. According to Professor Young mentioned that IUU fishing is a problem of, or to some extent can be characterized, is belong to marine environmental protection. But as far as I know, according to UNCLOS, for example, we have different parts regarding to fishing or marine environmental protection. And also from the case law, we know that overfishing, of course, can make a damage to environment. For example, the South China Sea case between China and the Philippines, when doing fishing, damaging the rare or endangered ecosystem, for example, or overfishing, of course. But in general, the question here is, in general, is whether the IUU fishing is the sources of damaging for maritime environmental protection in general. Listening to the issue regarding to IUU fishing and also discharge of pollution from ship, it's led me to the final comments. It's also is about the enforcement of all of these regulations. We know that some the violators of all regulation are some entity from a party member or from the third party, the non-signatories of all of this convention. So how we can enforce the regulation to violators? So this lead me to the comments about the need for more cooperation on the maritime enforcement regarding to this kind of practical activities. And it's also relating to concerning the information sharing and capacity building also. So thank you again, and again I listened with very interest with all three presentations, and look forward to your exchange. Thank you.
Okay, thank you very much for these questions. I will now ask Professor Young first to respond to these questions, which I addressed to her. Thank you.
Thank you.
Professor
Thank
Young,
you very
please.
much. Thank you, Judge Chadha, and thank you to the discussants for these stimulating questions and for the engagement with the paper. Let me begin with comments to Professor SHIM, who raised some very important points about the fisheries subsidies reform. You come up with the question, well, are there cases in which fisheries subsidies are actually positive for the protection and preservation of the marine environment? And definitely that can be the case, as it is in the case of energy subsidies in the context of climate change, where, to put it crudely, you have fossil fuel subsidies as a negative and renewable energy subsidies as a positive in climate change mitigation. So I don't want to suggest in my presentation that the state is bad in providing support to the marine sector, and definitely the state must be responsible in promoting the economic conditions that can support the protection and preservation in the marine environment, and that often takes the form of grants, loans, aid, and other financial support. So definitely there can be good subsidies, there can be bad subsidies, and states have for the past decade tried to isolate categories of each in the WTO negotiations for subsidy reform. In that process, a lot of material has been brought to the WTO, which is not a fisheries organization, which has provided expertise and experience on behalf of the nationals in talking about ship construction programs, the operational side of scrapping, how to ensure that capacity is not simply displaced if it is taken out of the system, and so on. At the moment, the WTO negotiations have really focused in on the concept of IUU fishing because it does provide some credentials for bad subsidies. You know, there already is a benchmark within the UNCLOS and FAO regime for illegal, unreported and unregulated fishing, and the WTO can draw on those standards in proposing reform. At the moment, the negotiations are very much caught up with how listing of vessels is taking place, wanting to ensure that there is due process, that any affected state has an ability to participate in a vessel listing decision, a right of a hearing, and so on. And so, of course, the issues of cooperation and legal procedure come to the fore. Another standard is for fisheries subsidies that are used in cases where fishery stocks are already seen to be overfished. And of course, the WTO there relies on FAO and other organizational assessments of stocks. So again, that outreach is really important in providing integrity to the disciplines. Now, the WTO is not isolated. It hasn't operated in the past without regard to other international organizations. And in the food safety context, with one of the agreements, the sanitary and phytosanitary agreements, there are precedents already for how the WTO can operate to cooperate and consult with other international organizations. And I predict that that is going to be necessary in the fisheries subsidies context. Judge Chadha also raised the very important point that there's no hierarchy in dispute settlement bodies. So there will be potentially disputes about subsidies in which a WTO panel will have to draw on the expertise and perhaps even engage in comity with established tribunals that have that relevant expertise on UNCLOS matters. Let me turn to Dr. Thuy's comments. He asks first about the relationship between IUU fishing and marine environmental protection, a very valid question that has come before the tribunal itself. So in the advisory opinion sought by the Sub-Regional Fisheries Commission in 2015, ITLOS did draw connections between IUU fishing and the Article 192 duty to protect and preserve the marine environment. So we do have jurisprudence to support the linkages. And definitely, I think it's important to raise the point you raised, which is that it's not just about overfishing per se, it's also about harmful fishing practices, vessels that are not complying with established regulations relating to gear size, seasons, restrictions, and so on. And these are all bound up, I think, in the general duty to protect and preserve the marine environment. Dr. Thuy, you also asked about enforcement, and given my work in trade law, that question often comes up to me, not speaking about criminal enforcement or indeed about the regularized monitoring and surveillance of vessels, but instead asking about trade measures and the use of catch documentation schemes to try and seek to better enforce the law of the sea. So definitely we have precedents of that occurring, and I think given the topic of today's conference and this particular panel, it's important to mention the need for cooperation in the operation of all of those enforcement schemes. So when catch documentation schemes are used and when quite onerous consequences result from a failure to persuade an importing country that fish have been caught sustainably, there needs to be that sense of due process, the right to a hearing, and all of those legal issues that we need to be careful to observe, which are all, I think, bound up in issues such as the duty to cooperate, duties of due diligence, and the due regard that states must have for one another in the exploitation and sustainable utilisation of resources of the sea. That concludes my comments. Thank you again for your engagement.
Thank you very much, Professor Young, for your responses. I'll now give the floor to Professor Proelss.
Thank you very much for the questions. I'd also start with the issue which was brought up by Professor SHIM, and that has to do with the different categories of scrubber systems. And you're perfectly right. What is called the open scrubber systems using fluids for the washing process is just one of the relevant categories. And obviously, if we speak about discharges, it's the only relevant category. Taking into account that closed or dry or I should say, scrubber systems would, result in a situation where the pollutants in whatever form remain on board. Notwithstanding this, there then is the question how to dispose of what is left on board of the ship, and that would imply that port reception facilities are to be used, and the European Union has indeed future-proofed its port reception facility directive just at the beginning of this year in order to make it possible to apply with regard to these other scrubber types. Now, what does that imply? It implies that, if you have to use port reception facilities for extra substances, you have to pay more as the ship owner. So from that perspective, the open wet scrubber systems are, from a purely economic viewpoint, more cost effective, which is the reason why still they are quite widespread. Having said all that, the European Union has indeed, as I tried to say and highlight, called upon the member states to think about ways to completely ban these systems. At the same time, that would obviously imply the sulfur directive to be changed, which I think is going to happen anyway, because I'm not even sure whether this idea of making the use of scrubbers mandatory was done on purpose, or rather whether that is a drafting mistake which has resulted in an awkward legal situation. Questions of Dr. Thuy. Also, thanks very much. That gives me the possibility to say a few words about enforcement. Well, why should the European Union regulate issues which have been dealt with on the international level anyway? Now, one of the reasons is that the IMO usually, but not always, establishes minimum standards with regard to which states parties to the relevant instruments are generally free to go beyond in terms of the level of environmental protection. And do not forget that the EU, at least the Commission and the Parliament, not necessarily the Council, consider themselves as, front runners within the realm of environmental protection. There is a certain tendency to go beyond the standards that have been accepted on the international level. And that has significant consequences for the member states, taking into account that the EU is one of the very few numbers of international systems which provides for a compulsory system of court jurisprudence with regard to any question of European Union law. And if and to the extent to which the EU decides, by way of legislating, to implement certain international documents within its own legal system, it is the European Court of Justice which is then the competent body, and also taking into account that the EU law foresees a special proceeding that can be initiated by the Commission as well as other member states, entitled Treaty Infringement Procedure, by which non-compliance by the member states with regard to EU law can be sanctioned and enforced, including penal monetary damages and the like. So that is, one of the reasons why this is done. And it has been done within the realm of environmental protection quite effectively, as can be demonstrated by referring to the Aarhus Convention on public participation, access to justice, and others. And Germany is one of the countries that could sing a nice song on what, this kind of non-compliance proceedings could mean for a member state. But what about the external world then? What about third states? That was also something you addressed. Now, two perspectives on that. First, the EU tries to exercise political pressure on the globally competent actors in order to, go follow the path to stricter measures first. And it seems at least some of the institutions of the EU seem to accept to even go as far to violate or put the member states in a situation where they are forced to violate international legal standards in order to exercise that pressure. And it was successful with regard to the introduction of the mandatory double hold requirement concerning oil and gas tankers, right? So, there's a precedent there. Secondly, the jurisdiction of the European Court of Justice, as well as the legal position of the Commission, are based on an extremely broad conception of jurisdiction, arguing that essentially every ship entering the port of one of the member states is under the full jurisdiction of EU law. Now, personally, in light also of the North Star decision rendered by the International Tribunal of the Law of the Sea, I don't think that this is correct. However, the Court of Justice of the EU has permanently based its jurisprudence on the idea of the EU legal system being an autonomous legal system, essentially saying we don't care about what, international tribunals and what international law say unless it is in line with what the EU says, which is kind of, just not the right order of things. I have argued in several publications, which I, cannot go into detail. Last remark, if I may, concerning pollution from ships and discharges, there is indeed one, respectively two provisions in the Law of the Sea Convention that foresee extraterritorial enforcement powers, and that is in particular Article 218. So when it comes to discharges, the situation is probably different than with regard to other potentially extraterritorial ways of exercising jurisdiction. But yes, there is a certain issue and a problem here, but I don't see any, different approach, a more reluctant and careful approach concerning jurisdiction on the side of the Court of Justice of the EU, appearing. Thanks very much for the questions and for giving me the opportunity to clarify.
Thank you very much, Professor Proelss, for your clarifications and responses. I give the floor now to Professor Harrison. You have the floor, Professor Harrison.
Thank you. There were quite a number of questions directed at me, all of them not easy, and I could probably spend another 20 minutes talking about them, but nobody would thank me for that. So I'm going to keep this fairly brief, and apologies to the...
I think we are out of time.
Yes.
So I would request you to be brief. Thank you very much.
I will, I promise. Antarctica is a complex region because of the Antarctic Treaty, but I think it's fair to say, the vast majority of the Southern Ocean is treated as areas beyond national jurisdiction. That makes cooperation particularly important in this region, more so probably than any other region. The question about third parties, I think, is a very good one, and I dealt with it in a bit more detail in my paper. In a sense, the need for coordination between the regional institutions and other, particularly global institutions, is in large part to try and make regional measures more effective. It's particularly the case with shipping measures. Clearly the Antarctic institutions have adopted measures relating to pollution ships, but they're only binding on the parties. If they want them to have more effect, they need to engage with the IMO, and there are several examples of them having done that. Through the negotiations of the Polar Code, there was a lot of backwards and forwards between the regional institutions and the IMO. Guidelines on ballast water exchange in Antarctica first developed in the region, but then later adopted by the IMO, and that gives those guidelines broader effect. Slightly different with fisheries, I think, because of the fish stocks agreement, and certainly for parties, the requirement that anyone wanting to fish in a region has to apply measures adopted by regional fisheries management organizations. Having said that, there are still reasons for cooperation between CAMLA. Professor Young mentioned catch documentation schemes, and those were developed by CAMLA as a very effective enforcement tool to try and promote kind of the values of the regime in an effective market-based way. One of the ways in which CAMLA has cooperated with adjacent RFMOs is to try and roll out its catch documentation scheme and encourage other RFMOs to apply it when they are regulating the same stocks, particularly toothfish. So the MOU between CAMLA and the Southern Pacific Fisheries Management Organization explicitly deals with cooperation on catch documentation schemes. So on enforcement as well, there is cooperation here. I will then jump to the question about the BBNJ, and what that treaty is going to say is the $1 million question, and I don't know the answer to that. Nobody does right now. Clearly, there's going to be a compromise. Clearly, there are very divergent views as well. My only reflection I would add very briefly, I mean, we could spend a long time in it, but there are clearly lots of good examples of regional cooperation. There are existing tools that can be used. I'm not entirely convinced we need a new global body to make these decisions on behalf of the regions. I think that's problematic from the not undermining perspective of the mandate of the conference. There's also a danger that the disagreements at a regional level will simply be shifted to a new global body as well. But I think what a new global body could usefully do is provide an element of accountability for regional discussions. In a sense, regional institutions managing areas beyond national jurisdiction, despite the fact that they may not involve every single state, are, from one perspective, doing it on behalf of the international community. That's recognized in the preamble to the Antarctic Treaty, to the CAMLA Convention. And in a sense, having some accountability to a global institution, and that global institution being able to kind of make recommendations and maybe sway the debate at the regional level through kind of an emphasis on particular principles, could perhaps help shift the debate at the regional level. But at the end of the day, a lot of this is about political will. And I'll stop there.
Thank you very much. I think it's now my very pleasant duty to thank all the three speakers, Professor Young, Professor Proelss, Professor Harrison. Thank you very much for your excellent presentations. I also thank the two discussants, Dr. SHIM, Dr. Thuy, for initiating the discussion. And now I also take this opportunity to thank the organizers once again for giving us the opportunity to participate in this conference. And with these words, I conclude the session. Thank you very much.
Thank you so much, Judge Chadha, for your smooth moderation of session 2. You have guided us wonderfully through this session. Thank you very much, speakers and discussants of session 2, for your informative, insightful presentations and comments.